former attorney meant when he said,
Nick Reiner is not guilty.
It's not guilty by reason of insanity.
There is some critical evidence that could result in a not guilty verdict from a potential jury.
We feel that we have no choice at this juncture but to withdraw his counsel and ask to be relieved.
Jackson appeared in court today and he asked the judge, he said, I would like to be removed as counsel of record for this case.
He is so delusional right now that he can't understand how that ended up putting him in jail.
Nick Reiner's high-profile lawyer jumps ship.
The courtroom doors swung open, but the man everyone expected to see wasn't there. Instead, one of America's most famous defense attorneys was walking away from a case that had the entire nation watching. What he said next sent shockwaves through the legal community and left everyone asking the same question. Why would a lawyer who never loses suddenly abandon his client? In California, a young man named Nick Reiner was supposed to face arraignment for charges that would make your blood run cold. But instead of the legal proceedings everyone anticipated, the courtroom erupted in confusion when Alan Jackson, the same attorney who'd just secured a not guilty verdict in one of the most watched trials of the summer, suddenly withdrew from the case. This wasn't just any lawyer stepping down, this was a legal heavyweight known for taking on impossible cases and winning them. The withdrawal came with a cryptic statement that only deepened the mystery.
And Quinn, and with Mr. Reiner's understanding and consent, would ask to withdraw as counsel of record based on the conversation that we've had in chambers. We feel that we have no choice at this juncture but to withdraw as counsel and ask to be relieved.
Nick Reiner was supposed to enter a plea in court yesterday, but that did not happen. His high-profile lawyer told the judge he is withdrawing from the case.
Jackson appeared in court today and he asked the judge, he said, I would like to be removed as counsel of record for this case. And he said, quote, I have no choice but to ask for this.
Nick Reiner's high-profile lawyer jumps ship.
Standing on the courthouse steps, Jackson delivered a message that seemed carefully crafted to say everything and nothing at the same time. He claimed he was legally and ethically prohibited from explaining his reasons for leaving, but then dropped a bombshell that would echo through every legal blog and news outlet in the country. According to California law, he insisted, Nick Reiner was not guilty of murder. He repeated it twice, emphasizing each word as if daring the media to challenge him.
To the law in California, Nick Reiner is not guilty of murder. Print that. Print that. We wish him the very, very best moving forward. And that's all I have today.
There is some critical evidence that could result in a not guilty verdict from a potential jury.
But here's where things get really interesting. Legal experts immediately picked up on something crucial in Jackson's wording. He didn't say his client was innocent. He specifically said that pursuant to the laws of this state, Reiner wasn't guilty of murder. For those who understand legal language, this distinction speaks volumes. There's a world of difference between factual innocence, meaning you didn't do it, and legal innocence, meaning the law might not hold you responsible even if you did. This careful phrasing sent legal analysts into overdrive. What Jackson seemed to be telegraphing was a defense strategy that would challenge not whether his client committed the acts he was accused of, but whether he could be held legally responsible for them.
Former attorney meant when he said,
Nick Reiner is not guilty.
It's not guilty by reason of insanity.
To the law in California, Nick Reiner is not guilty of murder. Print that. Print that. We wish him the very, very best moving forward. And that's all I have today.
His former lawyer got up and said he's going to be found not guilty. That's code for not guilty by reason of insanity.
It's been reported that his defense, they want an insanity plea.
In California's legal system, there are several ways someone might not be guilty of murder, even if they cause someone's death. The most dramatic of these defenses, and the one that seemed to be emerging from Jackson's cryptic comments, was the insanity defense. Now, before we dive deeper into what this means, we need to understand why Jackson's sudden departure was so shocking. This attorney doesn't just walk away from cases. He's known in legal circles as a true believer, someone who fights tooth and nail for his clients regardless of public opinion. His reputation was built on taking seemingly impossible cases and finding ways to win them. So when someone like that suddenly exits stage left, it raises serious questions. The timing of his withdrawal provides crucial clues. Jackson had been on this case from the very beginning, showing up at crime scenes, holding press conferences, and doing everything a high-profile defense attorney does when building a narrative for their client. He'd already invested significant time and resources into the case. Walking away at this stage isn't something lawyers do lightly, especially lawyers of Jackson's caliber. Legal insiders immediately began speculating about two primary reasons for such a dramatic exit: conflicts of interest or money.
The other ground for permissive withdrawal, and Alan needed permission of the court or his client to get out, he can't just quit, would be the client made it unreasonably difficult to provide representation.
Why did lawyer Alan Jackson quit Nick Reiner's case? Well, apparently Nick Reiner believes he's the victim of a conspiracy, guys. Well, that and the fact that his family has now completely cut him off and is refusing to pay his legal bill.
The conflict of interest theory seemed unlikely because any competent attorney, especially one as experienced as Jackson, would have conducted thorough conflict checks before taking the case. These checks are standard procedure, designed to identify any potential issues that might prevent an attorney from representing a client. If Jackson had done his due diligence, and there's no reason to believe he hadn't, any conflicts would have been discovered much earlier. That leaves money as the most probable explanation. High-profile criminal defense doesn't come cheap. We're talking about a defense that could easily run into millions of dollars, especially if it involves complex psychiatric evaluations and expert witnesses. The question becomes, who was footing the bill, and why did the money suddenly dry up? Here's where the story takes another twist. Sources close to the case suggested that the funding for Reiner's defense was supposed to come from his family's estate, but when you're dealing with a case where the victims are family members, the financial dynamics become incredibly complicated. The potential beneficiaries of that estate might have very different ideas about whether family money should be used to defend someone accused of such serious crimes against other family members. The replacement of Jackson with a public defender speaks volumes about the financial situation. If there was another source of funding available, if another wealthy benefactor was waiting in the wings, they would have hired another prominent defense attorney. The fact that the court immediately appointed a public defender suggests that private funding for the defense had completely evaporated. But the money issue becomes even more complex when you consider the type of defense Jackson was apparently planning. Mental health defenses are notoriously expensive. They require extensive psychiatric evaluations, multiple expert witnesses, and often involve lengthy competency hearings before the actual trial even begins. We're not just talking about attorney fees here. We're talking about potentially hundreds of thousands of dollars in additional expenses for experts and evaluations. This brings us to the heart of what makes this case so fascinating from a legal perspective.
Son of famed director Rob Reiner made his first court appearance today.
For years, Nick had undiagnosed a mental illness called schizoaffective disorder. He is so delusional right now that he can't understand how that ended up putting him in jail.
The insanity defense that Jackson seemed to be telegraphing is one of the most challenging defenses to mount successfully. In California, the burden of proof for an insanity defense falls on the defendant, not the prosecution. This reverses the usual dynamic in criminal cases where the state must prove guilt beyond a reasonable doubt. The standard for legal insanity in California is extraordinarily high. The defendant must prove that at the time of the crime, they either didn't understand the nature of their actions or didn't know that what they were doing was wrong. This might sound straightforward, but in practice, it's an almost impossible bar to clear. California courts have rejected insanity defenses in cases involving defendants who believed they were vampires, who drank blood, who heard voices commanding them to kill. The state's skepticism toward insanity defenses is legendary among criminal defense attorneys. But here's what makes the Reiner case potentially different. Reports emerge that he had recently changed his medication before the alleged crimes. His behavior had reportedly been escalating, becoming increasingly erratic in the days leading up to the incident.
Nick was taking medication for schizoaffective disorder. And 1 month before the murders, the doctors changed those medications.
You know what? You're gonna have to bail me out of jail. I'm gonna go show that.
Get crazy. I get crazy.
Oh,
yeah.
okay.
You don't want to set me off.
For a defense attorney, this medication change could be the key to mounting a credible insanity defense. The medication angle introduces a fascinating legal question. If someone's mental state is altered by a change in prescription medication, can they be held fully responsible for their actions? It's a question that strikes at the heart of criminal responsibility and free will. Defense attorneys know that juries can be sympathetic to the idea that medication changes can cause dramatic personality shifts and impaired judgment. However, even with the medication factor, the defense faces significant challenges. Evidence suggested that Reiner took steps to conceal his actions after the alleged crimes. He reportedly went to a hotel, closed blinds, and engaged in what prosecutors would characterize as classic hiding behavior. From a legal standpoint, this is devastating to an insanity defense. If someone takes steps to avoid detection, it suggests they knew what they did was wrong, which directly contradicts the requirements for legal insanity. There's also the matter of what happened before the alleged crimes. Reports indicated that Reiner had a heated argument at a party, providing what prosecutors would argue was a clear motive.
And then I went back to, the roost. Remember the roost? No. That's what they called the little barracks. Okay. And I was like, how do I show these mother****s? And I'm crazy. Yeah. And I don't know if I told this last week, but they refused to give me meds. So to prove I was crazy, because they were like, you don't need any meds. Yeah, and I was like freaking out. And I was like, you don't think I need meds? And they're like, yeah, we think you're just all up to an act here. And
I got totally spun out on uppers. I think it was coke and something else, and I was up for days on end.
I was like, how do I show these mother****s? And I'm crazy. Yeah. So
the presence of motive, combined with attempts to evade detection afterward, paints a picture of someone who understood both the nature and wrongfulness of their actions. This creates a strategic dilemma for any defense attorney taking on the case. On one hand, the medication change provides a potential avenue for arguing diminished capacity or temporary insanity. On the other hand, the evidence of planning and concealment makes that defense extremely difficult to sell to a jury. There's another layer to consider: the difference between being found not guilty by reason of insanity and being found incompetent to stand trial. These are two distinct legal concepts that often get confused. Incompetence to stand trial means the defendant cannot currently understand the proceedings or assist in their own defense. Insanity refers to the defendant's mental state at the time of the crime. If Reiner is found incompetent to stand trial, he would be sent to a mental health facility until he's restored to competency. This process can take years, and in some cases, defendants are never restored to competency. It's a kind of legal limbo that can sometimes result in longer confinement than a criminal sentence would have provided. On the other hand, if he were found not guilty by reason of insanity after a trial, he would be committed to a mental health facility until he's no longer considered a danger to himself or others. If his issues were truly medication-related and could be resolved with proper treatment, he might be released relatively quickly. But if the underlying mental health issues are more fundamental, he could spend the rest of his life in psychiatric custody. This calculation, whether to pursue an insanity defense or not, is one of the most crucial decisions a defense attorney makes. It's not just about winning or losing, it's about what happens to the client afterward. A successful insanity defense might actually result in longer confinement than a guilty verdict with the possibility of parole. The public defender now handling the case faces all these same strategic decisions, but with different resources. Public defenders, while often excellent attorneys, typically don't have access to the same level of funding for expert witnesses and extensive psychiatric evaluations. This resource limitation could significantly impact the defense strategy going forward. Jackson's dramatic exit and cryptic statement have ensured that this case will remain in the public eye. His insistence that under California law, Reiner is not guilty of murder has set expectations for what kind of defense will be mounted. Whether the public defender will follow the same strategy or chart a different course remains to be seen. What we're witnessing is a legal drama that touches on fundamental questions about mental health, criminal responsibility, and the justice system itself. Can someone be so affected by medication changes that they're not responsible for their actions? How do we balance compassion for mental illness with justice for victims? These aren't just legal questions. They're moral and philosophical ones that challenge our understanding of human behavior and accountability. The case also highlights the complex interplay between money and justice. Jackson's withdrawal demonstrates that even in high-profile cases that attract national attention, financial resources can determine what kind of defense a defendant receives. The switch from a prominent private attorney to a public defender could have profound implications for how this case proceeds and ultimately how it's resolved. As this case moves forward, legal observers will be watching closely to see how the public defender handles the challenging hand they've been dealt. Will they pursue the insanity defense that Jackson seemed to be telegraphing? Will they have the resources to mount such a complex and expensive defense? Or will they chart an entirely different course, What's certain is that this case has already provided a masterclass in legal strategy, professional ethics, and the complex dynamics of criminal defense. From Jackson's carefully worded withdrawal statement to the immediate appointment of a public defender, every move tells us something about how our justice system works when pushed to its limits. The Reiner case forces us to confront uncomfortable questions about mental health, medication, and criminal responsibility. It challenges us to think about what justice means when mental illness is involved. And it reminds us that behind every legal strategy and courtroom maneuver are real people facing life-altering consequences. As we wait to see how this legal drama unfolds, one thing is clear: Jackson's parting words will echo throughout the proceedings. His insistence that under California law, Nick Reiner is not guilty of murder has set a standard that any defense attorney taking on this case will have to address. Whether they can meet that standard, given the challenging facts and limited resources, remains to be seen. That's it for today, folks. See you in the next video.